morning, everybody. Thank you so much for joining this panel entitled Independent Together, Combining National and EU Decision-Making. The GDPR has been characterized by many as an evolution rather than a revolution of EU data protection law. And when you look at the substantive principles and requirements of data protection law, this is certainly true. The basic concepts and principles have been quasi-identical and remained unchanged since the 1995 directive. But the accompanying enforcement architecture did undergo some significant changes. And one of these changes was the introduction of the consistency mechanism. Now, this mechanism entails that the final outcome of an enforcement action in a cross-border context is not determined by one supervisory authority alone, but by all supervisory authorities concerned, and in some cases also by the EDPB. Now, this type of composite procedure, where there is a decisional interdependence between national and EU level, may be new to data protection, but it is not something that is completely new to EU law in general. Now, the GDPR only entered into application 4 years ago, but the first 4 years of application have already provided a lot of insights. And one of them is the increased complexity that comes with applying cross-border and composite administrative procedures. So there is complexity stemming from the combination of applying different national procedures and different national procedural laws, thinking about things like the role of complainants, administration of the right to be heard, languages, deadlines, etc. But there's also the combination of the national and the EU level of procedures. And last but not least, there's also the combination of independent decision-making at these levels. And so questions of how autonomy and consistency relate to each other come to the fore. So the overall aim of this panel is to try to get a better understanding of what are some of the main challenges in applying this type of procedure, and also to think about ways forward in trying to address these challenges. And I'm proud to say we have just the right lineup of speakers to delve deeper into these issues. So we have Filipe Bastos, who is an assistant professor at Nova School of Law. We have Isabelle Vereecken, who is the head of the EDPB Secretariat. We have Johannes Caspar, who is a professor at Bucerius Law School, but also former head of the Hamburg Data Protection Authority. And we have Lisette Mustert, who is a PhD researcher at the University of Luxembourg. Now, I'm going to start my first round of questions with Filipe. Going back to the point that I was making earlier, saying that, okay, the GDPR is by no means the first EU law instrument to introduce so-called composite administrative procedures. You have studied such procedures in a variety of areas of EU law. How would you describe the main characteristics of such procedures, and what are some of the main challenges that can arise when applying them in practice?
Thank you, Brandon. Thank you for having me. Well, composite procedures are administrative procedures. They're intended to structure the way in which administration takes a decision. What is distinctive about the composite procedures is the interdependence between national and union decision-making. What do I mean by this? By this, I mean that the final decision of the procedure requires previously the contribution of national authorities like DPAs and union authorities like the EDPB. So why do we have these procedures all across the board in EU law? From the regulation of pharmaceuticals to the banking union, structural funds. Well, the simplest way to explain it is that national and union authorities are typically good at different things. Union authorities have a much better grasp of the needs of uniform implementation throughout the union. They have the jurisdiction to take decisions which are valid throughout the union. But at the same time, national authorities have a much better local knowledge, and often they are much better staffed and much better equipped in terms of financial means. So those are the functional reasons why composite procedures exist. But another reason is actually political. Member states historically have been quite reluctant to delegate more and more enforcement powers to the union administration. At the same time, the member states tend to agree that having uniform implementation is actually very good to achieve their political goals. So what is the solution? Instead of entirely centralizing or entirely decentralizing enforcement, You have a single administrative procedure where the institutional advantages of national and union authorities can be tapped into, right? So we can exploit the advantages of both while mitigating the respective disadvantages. Now, so composite procedures exploit those advantages. They make the best use of national and union characteristics in terms of administration, and they avoid political issues of too much centralization. If this sounds too good to be perfect, that's because it is. Because for all these technical and political advantages, composite procedures raise serious issues in terms of, frankly, rule of law requirements. Why do I say this? Because the different authorities involved in composite procedures are subject to different laws, national law and union law, because they are subject to different courts, right? Only national courts can review national decisions, only union courts can review union decisions. We have a sort of dysfunctional scenario where no court is actually competent to review the entirety of the decision-making process where national and union authorities are involved. So there's this issue, there's the issue of what standards of procedural rights you observe. Anyway, so these are some of the challenges that emerge. The Court of Justice has attempted many solutions to sort of fix this, compensate it. I think it has occasionally been very successful, but there's still a long way to go to completely fix these rule of law challenges.
Thank you much for those initial remarks, Filipe. Isabelle, I'd like to turn to you now. The EDPB has already had occasions to apply the consistency mechanism under the GDPR for the first time in the past few years. And so this not only meant applying some new provisions in the GDPR for the first time, it also meant trying to navigate some of these procedural complexities and issues. So based on your experience, what have been some of the main challenges so far, and how has the EDPB tried to overcome these challenges?
Thank you, Brendan. Hello, everybody. I think that the dispute resolution procedure in the GDPR is an excellent concept introduced when the DPAs do not manage to find consensus and an agreement. The EDPB then can ensure harmonization and consistency on legal issues. The EDPB has a strong role in this subject matter because we can adopt binding decision that will be binding on data protection authorities and that will resolve the disputes. Naturally, there are some challenges because there are many authorities that are involved, and by definitions, there is a dispute. So there is a challenge there. I will raise three main challenges that we are facing on a daily basis. First, the timing, because we have to deal with complex legal questions. By default, if there is a dispute between authorities, it's not an easy question. It will be a complex question. And sometimes we also have numerous questions for one case, because we can have multiple objections from one essay and even different essay raising on one decision, multiple objections, so raising different legal questions. And we have to resolve this within maximum 2 months. When you compare, the DPA have been working on the case for years, and we have to resolve that in 2 months maximum. And I'm not talking again with this Article 66, the urgency procedure. It's 2 weeks to adopt a decision. So last year, for instance, we received the privacy policies of Facebook, WhatsApp, analyzing data sharing between WhatsApp and Facebook and making a decision within 2 weeks with 31 authorities voting on this. So time is a challenge, for sure. At the same time, we have to meet the quality standards because we are dealing with sometimes very high level of fines, and we have to stand in front of courts. The second issue, which is, I think, interesting, is the fact that the entities that are voting and deciding are at the same time the ones which are in the disputes. So the lead authority and the concerned authority that have raised objection do have to vote on the decision which resolve the disputes. So we need a 2/3 majority. When we have like more than 10 authorities being in dispute, we need to convince them to vote on the decision. It's interesting because the national authorities then are wearing another hat. It's the EU hat. So they change of nature when they are meeting in front of the board. And the core purpose here is to bring consistency and clarity in the application of the GDPR. It works in practice. Sometimes they're a bit frustrated. They raise an objection. We said it's not reason relevant. So it's even not analyzed in the merits. But nevertheless, we always manage to get the 2/3 majority. And there are authorities that are voting in favor of the decision, even if we do not follow, they do not follow completely the national position. In practice this week, we had a binding decision. It was a conflict between the French and the Polish essay. They both voted in favor of, was a full unanimity. So years, months of disputes, within 1 month and a half, we proposed a solution, was solved. So that's the reality. So at the end, we have an EU-wide decision, which is better for the citizen, for the DPA, for the business. The third problem that I'm facing as a head of Secretariat is the resources. It has been raised there. The Secretariat is in a leading role for drafting, preparing those binding decisions, because we are independent. By the way, we can never be in the disputes. So this is why in the rules of procedure, we have a leading role there. We can be sometimes also helped by other essays, but those ones that are not part of the disputes. But we're trying to carry out this work as maximum in the Secretariat. In practice, we can face multiple procedures at the same time. Like last year, we had 5 between April and July. This year, 3. Right now, we just adopted 1. We have still 2 before July, maybe another one arriving in the summer. So in practice, I will tell you, for one binding decision, 65, we need to have like 3, 4 legal officers. For a 66, 7, 8. I do have like 13 people, legals. So when we have several, everybody is working on that. And at the same time, we receive every day access to document requests. We organize 400 meetings a year. And we are also issuing the guidelines of the EDPB, organizing the meeting, taking the minutes. So this is a reality that if we want to be able to work well, we need resources. And I'm a bit worried, to be frank, because I will make it more concrete for you. For 2023, even if the Commission is supporting here the Secretariat, the reality is that the announcement is that there will be 0 increase in 2023 for the officials in the Secretariat. So this is worrying. I'm worried, personally, on that matter. We also answer some questions, because I would like to come back on what was said yesterday on the right to be heard, for instance, because we are working and solving also issues, and composite procedure means that the right to be heard of company totally has to be fulfilled globally for the decision, national, European level. So it means that if a company has been fully heard at national level on all the document which is discussed at the EDPB level, it means that it's fulfilled and completed. It happens twice in our 5 binding decision, which is in the pipeline. 3 times we heard company because it was not completed. So for Accor, there is 1 big tech rate for the moment, WhatsApp and Facebook, even in the 66 procedure. Within 2 weeks, we managed to hear those companies. So we are hearing companies that we don't hesitate at the EDPB level when it's necessary. Thank you.
Okay, thank you very much for that, Isabelle. Johannes, turning to you. Before you went to back to academia, you were the data protection authority, the head of the data protection authority of Hamburg, and you were a very active participant in the EDPB, and you also participated in some of the first decisions under the consistency mechanism. Taking a step back, what's your perspective on the GDPR's consistency mechanism? What are the pros and cons?
Well, thank you for having me. It's a great audience here, and so we can exchange our views. My experience in this field, from the theoretical aspect and from the practical aspect, aren't so optimistic at all. I think the enforcement strategy, the enforcement architecture has many flaws in the GDPR. Enforcement has to be something which has been effective, efficiency, assertive, and all this lacks. Yeah? Because normally, if you think about enforcement, you have to think at first what comes before. Before comes an abstract, general term. It's the norm. The norm is something which must just place in reality. And enforcement is something to fix this normative level down to the earth, down to the ground. And therefore, you don't have to have any democratic issues in enforcement. besides the fact that enforcement power is legitimated in a democratic manner. But enforcement itself, it's not a cooperative structure, it's a hierarchic structure. And if you see, the GDPR offers us a cooperative structure, a consensual structure, and it's just something which should be the standard for a legislator, not for a decision maker. And this is a great problem, because you lose a lot of power, a lot of budget to just get into your infights, to discuss all the things you have to discuss to enforce law on the internal aspects between our colleagues and between the EDPB. So you lose a lot of power and assertiveness. This is just an abstract intro. When it comes to my experience, I just can say the whole process, it has three problems, I think. The whole process begins with the draft decision. The draft decision is in the hand of the lead authority. If the lead authority doesn't move, if the lead authority isn't active, nothing happens. The EDPB won't ever see a case when the lead authority doesn't get up. So it's like sitting in a bus, yeah, on the last row, sitting there and waiting for something which happens. We're sitting there waiting for the lead authority on the driver's seat, but nothing happens. The lead authority is inactive, omissive, and so the whole problem raises that we don't get the structure we have to get if it comes to safeguard rights and freedoms of people. So let's be frank. We have a double standard in European law when it comes to law enforcement on the European level and on the national level. Because on the national level, you don't have all these consensual structures. There you have the hierarchic structure, and there it works. So I think this it must be changed, this must be fixed. And let me just line out another problem with the structures in dispute resolution. There we have the situation that also the lead authority has it in its hand to fix the scope of the whole investigation. That means the lead authority can decide in a case, for example, you have a data processor and you have two problems. One problem may be to the transparency of the data processing. The other, there is a problem with the legitimate ground for data processing. So the lead authority can decide, oh, well, I'm looking into the transparency issue. The other issue I skip. And we'll come on with this later. This is a problem because there's no instrument which you can just implement as EDPB or as a concerned authority to urge this process into the direction that also an insight has to, an investigation has to be done on the fact of the legal ground of processing. So there is a problem in this power of the lead authority to structure the process. So we have to shift this power and we have to give more power to the EDPB and to the concerned authority.
All right, lots of provocations, very interesting comments. Thank you very much for those. I think we will unpack some of those ideas and statements in our next round of questions. But before turning to the second round, I'd like to turn to you, Lisette. So your research focuses on enforcement and accountability challenges in composite system of GDPR enforcement. What are some of your main findings so far when looking at the current system, also having regard to the first decisions on the EDPB under Article 65?
Yeah, so thank you first for inviting me. It's a real honor to be here. With regard to the board's first two decisions, I think this decision-making competence is a great potential for the board to clarify matters, and especially since so many core concepts of the GDPR are interpreted differently by national DPAs. But I think the way the system and the competences are shaped of the EDPB, but also the problems that arise with enforcement at national level hinder the board in actually adopting decisions that have real impact at national level. So the first two decisions prove that insufficient involvement of the concerned authorities by the lead authority at national level, for instance, because the scope of the investigation is very narrow, and there is perhaps a lack of exchange of all relevant information, that brings the concerned DPAs in a situation where they are not able to meaningfully participate in the decision-making process, not able to submit relevant and reasoned objections. And that objections are then also not taken into account by the board in its decision-making process. And if these objections are taken into account by the board, it is often also the case that the EDPB is actually not able to decide on a matter because it does not have all the sufficient information it needs. And the problem there is that the board can actually adopt a binding decision, but it has not had the competence to conduct an investigation itself or to collect any information. And it is very reliant on the national DPAs there. So a lack of such cooperation, either at the horizontal or the vertical level, is then on the other hand also something that the board cannot easily solve in its decisions. So in the first two binding decisions, we saw that the board stressed the importance of cooperation and also highlighted the obligation to reach consensus and to make use of all these cooperative mechanisms in the GDPR. But all the EDPB can do there is order the lead authority to act, to cooperate, but it is then very questionable if that changes anything, because the Article 65 guidelines only state that the lead authority shall address the matter and keep the EDPB updated. But is there anyone who is actually actively going to track well, what the lead DPA is doing with these orders of the EDPB? And on the other hand, the board also took a strong stance in certain instances. So they took the decision that the lead DPA had to adopt a corrective measure instead of a recommendation for the violation of a certain provision of the GDPR, and thereby even sort of shaping an enforcement strategy. It also concluded that other violations should be included in the final decision. But on the other hand, a decision is often very broadly formulated. So if a fine should be higher, the lead DPAs will adopt a higher fine, which can still be rather low. So I doubt whether that is very effective, very useful. And of course, the third decision was only adopted this week. And these are only some insights into the potential functioning, but I think there are already clearly some drawbacks to this system.
Looking forward also to reading your comments on the third decision once you've had a chance to read and digest. No, thank you so much for that. In the second round of questions, I would like to turn to the topic of independence. Independent oversight, I think Alette mentioned it also in your keynote. It's one of the hallmarks of the GDPR. It is embedded in the Charter of Fundamental Rights and even on the Treaty of the Functioning of the EU. Now, the consistency mechanism brings together a large number of independent authorities, making GDPR enforcement, in a way, a shared responsibility. So, Filipe, is this combination of independent decision-making something that also exists in other composite administrative procedures? Is the GDPR really one of a kind in this regard? What do you see as some of the distinguishing characteristics of the procedures under GDPR compared to other examples of composite administrative procedures?
Right. So thank you, Brendan. So as to the question of whether this combination of independence and the really obligation to decide together, if that is rare in European administrative law, it is absolutely not. This combination exists in areas as different as the regulation of telecommunications, but I think the most prominent example these days may actually be, well, either the ECN, the European Competition Network, and the single supervisory mechanism of the banking union. In all three examples that I just gave, the national competent authorities are subject to independence requirements, which not only are in substance identical to the independence requirements of of DPAs, they're actually worded in practically identical terms in the applicable legislation. So one should absolutely not confuse independence, which is the immunity from external pressures and instructions, with operating in a vacuum without any need without the duty, really, to cooperate with the other authorities which operate within this network. As to what is distinctive about the composite procedures of the GDPR, I think procedures like Article 66, or the urgent procedure, are not. You find procedures which are practically identical in essentially all areas of EU law, from consumer protection to agriculture. It's these urgent procedures where a measure is taken and then later confirmed or rejected. That exists in many areas. The Article 65 procedure, I think you can find some really distinctive aspects there that you would not find in other similar procedures. So the Article 65 procedure is by no means the only administrative procedure in EU law where national authorities are primarily responsible for working together and enforcing together EU legislation. And then if they are in disagreement, it goes up, so to say, to the unit administration for a binding decision to be taken to settle that disagreement. So this exists in many areas. What strikes me about the Article 65 procedure, what is distinctive about it, is that, so first of all, the deadline to decide. So the EDPB has 8 weeks to decide, right?
It's 1 month, it can be
Extended to
another
two.
month.
Exactly, thank you. So, exactly. I think it bears noting that in a practically identical administrative procedure to settle disagreements in the regulation of pharmaceuticals, this period can be as long as 140 days. And in the domain of the European supervisory agencies, so the Markets and Securities Authority, EIOPA, EBA, the regulations don't even specify a deadline. So I wonder, as someone external to the field, whether there is actually any justification to be so strict or perhaps even cruel with the EDPB. Speaking of cruelty, I think given the deadline that the EDPB has to decide, it has rather limited tools actually to gather information and to know how to decide. There are no real investigation tools, and what the EDPB can decide really is highly constrained by what the LSA believes to be the problem, right? Whereas in other policy areas, again, say in markets and securities, the European Markets and Securities Authority can actually look at the disagreement between national competent authorities and say and decide what actually the disagreement is about. So it defines the scope of the disagreement that it has to decide upon. So these are some of the issues that I see. There are some more, but I think these are the key ones.
Thank you very much, Filipe. And Isabelle, turning to you, I'd like to build a little bit on this idea of independence yet shared responsibilities for ensuring effective enforcement. And so the CGU in the Belgian Facebook case explicitly confirmed that supervisory authorities under the GDPR share competences and responsibilities when it comes to GDPR enforcement. And we've heard, yesterday and today about some of the key actions that the EDPB has in mind in order to streamline cooperation and greater coordination in these cases. what are some of those specific actions, and how do you think that this might alleviate some of the challenges that have been currently highlighted in the context of these procedures?
Thank you, Brendan. So at the EDPB, we are applying those binding decisions, those procedures, etc. And at the same time, we are shaping them and we are explaining them. So in practice, we adopted each time we made the first decision, we also accompanied with a set of guidelines to, in fact, embed in those guidelines, all the lessons learned and how we should do. So it's like, as you said, the more we do, the more we learn, the more we also make it easier for after. So we adopted directly the guidelines on the reason and relevant objections to explain what's the level of the, I would say, how an objection should be reasoned to be even analyzed at the merit in the content by the EDPB, because otherwise it would just be discarded. And then we made also those guidelines on Article 1A, where we describe it all the process. We explain the context of the right to be heard, how to make it. And we updated the rules of procedure to explain how a file should be complete. I need to underline the fact that indeed in this composite system, in fact, the consistency of the GDPR is broad at two levels. First level is the cooperation, the one-stop shop, where there will be one decision taken by the LSA. In practice, this is not an exclusive competence. As you said, it's a shared competence. So the objection, I mean, the other authorities can raise objection and make movement and even go to the EDPB if there is a problem. So when you compare with the past, in the directive, there were companies making business in different countries and having different decisions potentially conflicting. So, okay, it was good for the lawyers. They were calling all the DPAs to try to make a consensus and to try to have one single decision. Here, it's on our shoulder to make this working. So the Article 65 is coming like on a last resort. It's only when there is a dispute that it's coming to us. It's only happening times to times. I mean, it's normal. It's part of the process, as Denis said just right now. In the 4 years of the GDPR enforcement, the DPA has already reached 380 final decisions on the one-stop shop. That's the last figure of the 15th of June. And so in vast majority of the cases, there were a consensus and there were no dispute because there is very few cases where we had to intervene. So there is this rule of the EDPB, to try to settle disputes in the enforcement process, concrete cases. On the other side, also the EDPB is decided to support the cooperation and the enforcement action. Because swift and consensual resolution of case is essential, and there is no always a need to go for 65 decision, because I mean there is a high expectation of GDPR, so the faster it is the best also for the GDPR. So we are identifying numerous ways to cooperate. Thanks to the first experience on the first decision, as it was explained by Lisette, we saw that there was a need to have much more exchanges between the authorities, the LSA and the CSA. In practice, when you read the GDPR, that was how we did, or the DPA did also at the beginning. There is an exchange of the draft decision, etc. We realized it was so late for making this exchange. We had to build the cooperation from scratch, and to be much more, that the DPA needs to be much more proactive in exchanging information and much more comprehensive to reach this sincere cooperation level. So that's why we embedded in this first binding decision, the need to agree on the scope of investigation from scratch. And after that, we build on that also to shape the Article 60 guidance. That's the one-stop shop guidance. And this is one of the core messages there, is really to say, let's work from the beginning all together, sharing information. And as you said, independence cannot be used to bear cooperation, and confidentiality of cooperation is also not a limit of cooperation. So we clarify the role of the LSA and the CSA in those decisions. Then, aside of making those guidelines to further explain and to have consistency on how to use, the cooperation, recently also we had these guidelines on the method of calculation of the fine to ensure there will be consistency in the calculation of the fine. Then, apart from these guidelines and abstract explanation of the concept to foster and to boost cooperation, we developed concrete tools to make this a reality. First, the coordinated enforcement framework that was launched in October 2021 to have simultaneous and coordinated action. The first one was in the cloud, the use of the cloud in the public sector, 22 authorities. At the same time, in all the member states, were 90 authorities, I think, which have been subject to a joint investigation at the same time. In February 2022, we launched the super pool of experts, so to increase the capacity of the member states. So in practice, to make it a reality, so either there will be experts that will be exchanges between authorities, and the EDPB, in fact, is finance this. So we will pay for the travel, we will pay for the accommodations, etc. We are helping authorities. If there is one expert in one member, that can help another one in a member state. We also make a call for external experts, private experts, and we will also have those people that can also help the authorities and boost, I would say, the capacity because of the limited resources. In the end of April, you heard that there is this meeting in Vienna with the statement where there will be strategic cases where some authorities will work together with a specific timelines and to have swift results. In fact, we are building on practical experience. It was a discussion between 2 days between authorities, and we saw that there were some concrete experience where it's within the framework of the GDPR. Of course, in GDPR, you can cooperate as much as you want. But then there were some concrete experience in some member states where they led investigation hands in hands from scratch with some essays, and this led to performance, consensus, swift results. And so we want to build on that and to identify strategic cases and to make it more in a systematic manner. Then there is also the exchange of information on the national enforcement strategy to try to have annual enforcement priorities at European level. And the last one is the list of procedural aspects that need to be further harmonized at the EU level. And so we are collecting this information.
And we'll talk about that also, I think, in the last round. So thanks a lot for that. Johannes, now turning to you. You've heard a lot of initiatives on how to enhance cooperation, ensure more consensus. And I wanted to get your perspective of what's your take on some of these initiatives? What do you think they will do? What do you think that they will achieve in terms of effective enforcement?
Yeah, thank you. Let me please remark that I appreciate your efforts on the administrative level to optimize the working of the cooperation structure between the EDPB and concerned and the lead authority. But as I said, I'm not so optimistic that after 4 years of discussing these issues, we will come further on this track. It's always a small step forward, sure, but maybe we need a cut, and the cut is something which needs a legislation process. And this legislation process, there I could imagine, has got two approaches, the small approach and the large approach. The small approach is the approach where the legislator just takes the actors which are involved in this process and has the EDPB, the lead authority and the concerned authorities, but it then will bring new regulations for administrative procedures, especially in a situation where concerned authorities can step in an investigation when the lead authority doesn't react. So this could be a solution where we gain time and where we be more effective in starting investigations on the European level. And so this would be an interesting aspect for the legislator. Other aspects are just harmonizing an European administrative law for all these things, for all these issues which are involved in this procedure, especially the exchange of data. When it comes to trade secrets, you know this, we have a lot of problems by having national authorities which tell us, no, you can't have our information because there are business secrets on the way, and so we stop this exchange. This is one point. The other point is the duration of the procedure, especially the problem of deadlines. You have to have the same deadlines for this procedure in the whole of Europe, and throughout Europe there must be a harmonized structure. And you mentioned the right to be heard. This is also a problem. You can't even fix a procedure when there are different kinds of levels where you have cuts for the right to be heard. You have to have one harmonized structure for this, and this also consists the small approach. The large approach would be to make a cut, and what I said before, that the structure of enforcement is not a consensual structure of democracy and of participating. It's a structure of hierarchy decision making, and so you put it to a new or existing board and agency on the European level. You have a pan-European authority which then is competent for all these issues concerning cross-border processing, and it's regulating. And this could be the EDPS, as he is independent and competent for all data protection issues concerning agencies on the EU level. But this could also be a new kind of organization which should be funded and which could be invested with money and with budgets and with personnel which can fit to this task. For me, I would opt for the bigger solution, because I think that would make the decision process much more efficient and effective.
Okay, thanks a lot for those interventions. Now, Lisette, Advocate General Bobek, who I think for many people is one of the favorite Advocate General Bobek's, his opinions were always a great pleasure to read. He once famously said, making everyone responsible means that no one will in fact be responsible. What is your perspective on the manner in which the GDPR has allocated competences and responsibilities between lead and concerned supervisory authorities? And does this model, in your view, create a risk of dilution of accountability, or does it increase the chances of effective and complete protection?
Yeah, I think it is already clear, and we discussed it also yesterday, that competences and responsibilities are not equally shared among the national authorities. There's a very large role for the lead DPA, and as Advocate General Bobek also said in another opinion, there are mechanisms in the GDPR to overcome administrative inertia, as he called it, for concerned DPAs to actually push the lead authority to act. But it is then very important that concerned authorities actually make use of these tools when they have the feeling that the lead authority is not addressing a complaint or is not sufficiently investigating a complaint. And what worries me here is that it seems that there is a preference among DPAs to cooperate informally. So that means that they make use of voluntary mutual assistance rather than mutual assistance, informal consultation rather than formal consultation, or submit comments instead of irrelevant and reasoned objection. And that is a situation where there are no legal deadlines and there are no legal consequences if your request is not responded to. And on the one hand, such informal interaction is a good thing because it creates trust, you learn from each other, you can exchange practices on your national procedures and strategies. But on the other hand, it does not create the required peer pressure that the GDPR provides for with all these formal cooperation tools. And other ways to push a lead DPA to act is, of course, making use of the urgency procedure or requesting an opinion of the EDPB when your request for mutual assistance is ignored, for instance. But urgency is only presumed if you actually make use of a formal mutual request or a formal request to organize a joint enforcement action. So there again, it is very important that DPAs keep making use of formal cooperation instead of informally exchanging practices. And this is also very important for, well, the second part of your question related to accountability. And in principle, this whole system is very complex in light of judicial review. There is a system where you have to seek legal protection, possibly outside of your own member state, with the consequences that you will have to adjust to another language and a legal system that you are unfamiliar with. But also for courts, it is very difficult for a national court to assess a final national decision that is adopted on the basis of preparatory acts coming from several member states. And especially when cooperation then happens informally, it will be even more difficult to see where the responsibility for a certain part of the decision lies. And this problem is there at national level, but of course also at EU level. The system is even more complex and the board steps in, because the board will adopt a decision based on national input, but coming from several member states. And it can even result in a decision that is also adopted at national level by different national authorities in different member states, when the lead authority decides to partly act on, but the concerned authority adopts a decision to partly reject it. And then it is very complex to decide which court is actually responsible to review either the board's act or the national decision. And if the EU court is responsible, it will have to review national preparatory acts, possibly collected via informal ways of cooperation, which is highly problematic and certainly does not create does not lead to good protection for data subjects.
All right. I would like to still ask a last round of questions before turning to the audience. But I would like to ask you to keep your interventions perhaps a little bit shorter than we initially timed and planned, just because the discussion has been going on, and I want to make sure that everybody had a chance to express their ideas. But so one idea which has been raised, I think already several times during this conference, is that there may be a room for further harmonization in order to reconcile or to address some of the differences in national procedural laws and to further harmonize certain procedural aspects. Should this idea be taken forward, what are, in your view, the key elements that should be considered as part of such a procedural intervention? And would that be sufficient? Is there anything else that we would need to consider in order to further optimize enforcement under the GDPR? So please, I would say, Filipe, maybe you take us off. We'll just go in the order that you've intervened, please.
Thank you, Brandon. So I think there is really much to be said, but I will be brief. I've heard yesterday lots of references to not only harmonization, but in fact, discussions about centralizing enforcement eventually. And I think it's important to consider that in other areas of EU law, it becomes clear that both harmonization and centralizing or decentralizing enforcement, these are not binary either or issues. It's a sliding scale. It's a sliding scale that can be actually very nuanced, with different tasks being allocated to the authorities that can best execute them. So I would say, but I'm biased here, that it makes a lot of sense to look at how reforms of administrative governance in other areas of EU law have what they have looked like. And you see that in some areas where there used to be administrative procedures which are identical to Article 65, those were thought too cumbersome and too difficult, too complex, and were later replaced by centralized enforcement procedures. For example, novel foods, the regulation of goji bears and chia seeds, that sort of stuff. So that's one example. I think also one should not also underestimate what one can already do without reform. I think that a dialogue between data protection community and the EU administrative law community will be vital actually for both parts, for both sides, because many of the issues that are raised in terms of procedural protection, judicial review, the right to be heard, for example, many issues that are relevant from the point of view of the observance of those rights have already been settled in the case law of union courts for structurally identical procedures. So I think that a quick, albeit clearly a very imperfect and very partial fix to some of the procedural gaps that you identify in data protection could already be addressed by taking into account the current state of EU case law.
Okay, many thanks. Isabelle?
Yes, we are carefully analyzing this case law, not only, we're also reading your articles in the field, so we are quite well aware about the state of play on this subject matter. So yes, you heard that at the EDPB we would like to invite the Commission, to take an initiative to have more harmonized horizontal provision in provision in administrative law. And what is important here, I think I was happy to hear that the Commission is ready to go for it. That's an amazing news, I think. We are already collecting the feedback and the ideas coming from the authorities. I mean, I don't want to disclose too much in advance, but of course there are the questions on the position of the complainants in the party of the procedure, the question of the deadlines, as you raised, the question of admissibility of complaints or dismissal of complaints, language, amicable settlements, etc. But this is one of the actions that we are doing, because you ask, is it sufficient? But it's not the only thing that we are doing. In practice, as I said, we are also making this closer cooperation a reality with different tools that we are putting in place, making methodology. We are developing also, we would like to develop methodology of investigation that will be, in fact, developed by one SA and shared to all the others. IT tool also for remote investigation, etc., to develop things, making available to everybody. So many actions. And then I would like to make also a point that, okay, this conference is about putting the SA, the DPAs in the grill, about the enforcement activities, but the ultimate goal of this is compliance. And compliance is not only enforcement. There are many business willing to be compliant. I'm sure many of them are here today. And I worked 10 years in a DPA in Belgium, and I have very good relation with DPO that are also friends and willing to work within the business to develop data protection activities. We worked a lot on co-regulatory tools, meaning win-to-win, hands in hands with the DPAs, business that wants to have BCR, code of conduct, certification. The EDPB is working to shape all those tools, in fact, to boost also compliance, developing standard contract between controller and processor, making it more easier for the business to have standard contract. Also at the EDPB level, we do not have normally a duty of awareness and explanation for the business, but we decided to have targeted information for small and medium enterprises and to make it business. The people that do not have the money, the lawyers, to also be compliant, to make their life also easier. So ultimate goal is compliance, and it's important to underline that, because enforcement is important, but it's just a part of the activity of a DPA, and I cannot hear that let's have them working. This is coming from someone that never worked in a DPA.
All right.
You were there too.
Yeah, of course. And still do, actually, but no.
But at national level.
No, indeed. And I think, to the extent that there's an idea that it's about grilling DPAs, I don't think that's the case. I think it's really about thinking about how we can be more effective together. Lisette, please, your thoughts on this, and then Johannes, and then I would really still like to turn to Q&A for the audience. Just a second, please. Lisette, please go ahead.
Thank you. Well, first of all, I think there are possibilities within the framework as it is, but especially with an eye on the role of the EDPB, I think it would be good to reconsider its role. And that doesn't mean that I would argue that centralization is a good thing, because I really think we need the national expertise and the resources to make effective enforcement work. But perhaps the fact that the EDPB is somewhere at the end of the line of the decision-making process, that it cannot collect information itself and only in very exceptional circumstances ask additional information throughout its decision-making process, I think that are simple things that could already make the role of the EDPB at least more efficient, and perhaps also consider when this dispute resolution mechanism can be triggered, in the sense that are you dependent on the lead authority to send a case forward, or other ways to intervene in the decision-making process at national level. And regarding the need for further harmonization of procedural rules, I think it's highly important. I have my doubts about the feasibility of this, and also about the legal instruments that will be used to harmonize such measures. I think binding instruments will be possibly politically unfeasible, and adopting another guideline, which is non-binding, is perhaps not really effective. And of course, it is very important that these guidelines are there, that there is a sort of consensus among DPAs, but they are non-binding in practice, and their legal and practical effects can be studied. And then still, I think a problem with the guidelines is that they are not very consistent in their wording, in the sense that some aspects are super strictly formulated, and an authority shall and must do this and this and this. But on the other hand, it also leaves a lot of room for member states to deviate. And yeah, so I doubt about what kind of shape procedural harmonization will have.
Okay, so still a lot of questions there. Johannes, very quickly, please.
Well, nothing against diversification. This is great, and democracy and consensual discussions, but I think that is not the way we should regulate WhatsApp, Facebook, and Google, and so. This, I can tell you, was my perspective, being on the level of a national authority in Hamburg. We were competent for all these global actors, and believe me, with 30 people, staff in your office, you can't you just move forward. If you want, you must neglect other things. So we were competent also for the whole administrative procedures of data protection in our state. But then you have some kind of 30 people, and this is not enough for just standing on the same level as the big companies. So I think this procedure must go into the centralization, and as far as this won't do, then we have to see how we can safeguard rights and freedoms of people in the small solution procedure. We had some kind of contributions today. But let me just stress upon one thing, because I think we should see what is at stake if we don't move. At stake are the rights and freedoms of people, and the swift safeguarding of these rights and freedoms, but also at stake is a fair competition procedure on EU level. Because if you speak with SMEs or also bigger companies in the national field, they tell me, hey, what's they doing there? Here we have a structure of enforcement in 3 to 4 months, we get a fine, and there they won't impose any fines for years when it comes to the big players. And this is a problem for the whole acceptance of the GDPR. It can't work if you have the principle catching the fry and letting the big fish go. This won't happen, and this won't successfully be implemented in the last run. So we have to change the system, and we heard some kind of suggestions here. I hope very much that there will be a movement and the legislation will just step in. Thank you.
Thank you. Thank you. It is finally your turn. Apologies for the long wait. I see Boyana, you've been jumping to intervene. So can we get a mic over here? Then I also see Romain and Mr. Hoffman and Florence in the back. And I think we'll cut it off at that point. There will be a coffee break. Let me just already reassure you that the coffee break will take 30 minutes. And so I'll give you an updated timing once we're concluded. But please, Boyana, kick us off.
I have a question. It seems to me we are here dealing with the symptom, not the cause. The symptom is these complex procedures, but the cause is the fact that DPAs see things differently. They don't have the same level of maturity. Immaturity. They don't have the same level of understanding what the priorities are. They don't same the level of agreeing what matters. They don't same the same risk-based approach that GDPR requires them to do. So what can we do, or don't have the same vision as to whether we punish companies or we get them to comply? And I would say you get them to comply through different ways than fines. Fines don't do anything. But, so what can you do, EDPB, I think, to actually drive that convergence, to train, to discuss, close yourself in a retreat for 7 days, thrash things out, what matters, because we need that same agreement. It is unfair on people as well. If I'm born in Czech Republic, or I'm born in Belgium, or I'm born in Ireland, I will have a different answer, or Germany from DPS, but that's not normal. It shouldn't be the case. It doesn't matter where I live, where I move, I should have always the same answer from any DPA on any question of data protection rules. And I think that's what DPAs need to do. I know they're not there, but to me it's that soft. That's what I think board must do now, in my opinion. Okay. What do you think?
Thank you very much. Yeah, I was about to say more a statement than a question, but nevertheless, I would encourage you to reflect upon it in your reactions. Let's first take the rest of the questions, just again because of time constraints. So, Romain, if you would please.
Thank you. I would be like the same statement, of course, but on the side of the complainant, of course, it's quite surprising for us. When we file complaints now to see different national procedure, of course, when sometimes you're heard by the national procedure, sometimes you're not, sometimes you're supposed to be heard, sometimes you're not supposed to be heard, but still heard, and then just tell you that you can go to EDPB, but maybe you will not go to EDPB. We have also a pending procedure that were confirmed by the CNIL and the DPC to go to EDPB. We're now waiting for EDPB, and I totally agree with you. It's incredible that EDPB has to issue a decision in 1 month, whereas other DPAs can wait 4 years to have a draft decision. It's crazy. I don't really understand the... So my question would be, how would you address the data subject place in this procedure, like being heard or not in the national procedure? We also ask as a data subject to broaden the scope. You were mentioning the scope of the procedure. We ask the DPA to broaden the scope. Some DPAs support us, like the DPA when we file a complaint support our request to broaden the scope, but the lead DPA, and I will not name them because we all know who they are, refuse to broaden the scope of the investigation. So we just arrive at EDPB with a narrow scope, despite the fact that we both, NOIB and the DPA, ask to broaden the scope. So you understand that when you arrive at EDPB, the decision will be too short. The scope will be too narrow. And that's, of course, a statement, but the question, how would you see some options to address this issue? Because, of course, we are not in the end of the day.
We're definitely not at the end of the day, but we're entering into the end of the panel. So please, Mr. Hoffman, your question. And then also, I think Florence Renel from the CNIL also had a question. And then I'm afraid we'll have to, then of course we'll hear from the panelists, and then I'm afraid we'll have to wrap up. So please.
Yes, thank you very much. I mean, the problem seems to be very much the national discretion in how they lead, how the lead authority leads the investigation, what they take on, what they do not. So many policy areas, competition law was mentioned, European Public Prosecutor's Office now allow centralization of the leading of the investigation. And that is the question, isn't that actually the approach to say, for certain type of procedures, we need a European lead authority? Just as a last remark, for the procedural rules, yes, we need harmonization. I think the Research Network on European Administrative Law Renewal model rules has a whole set of ready-made, shelf-ready elements. So I hope one can look also into those.
I think there definitely will be people interested in that reference. Please, Florence, and then I would like to turn to the panelists.
Thank you. Thank you very much. Oh, it will be very short. It's just a comment, a remark. on this idea of centralization, and just to recall that we are talking here about protection of fundamental rights of people, and that we really need to pay attention to that and to keep the link, the relationship with the data subject. And it's true also for companies. I mean, we are accompanying companies at national level, and we need also to keep this relationship. So just to be careful about this idea of shifting competence. Proximity is really at one of the cornerstones of our data protection regime in the EU. And so just to react also to the matter of resources, you're totally right. We have a subject of resources, but maybe we have to find some imaginative solution to utilize our resources to handle those kind of cases. And in fact, it's what we have done with the Vienna Declaration and statement. It's to also to organize ourselves on a strategic case of major importance. So just it was just a quick reaction on this idea of centralization.
Okay, thank you very much. So indeed, a lot of more, I would say, still helpful statements rather than questions. But please, I would like to ask each of you to share your concluding thoughts on some of the elements that are raised. You're free to pick and choose, and then we'll definitely be able to continue the conversation over coffee. Please, Isabelle, take us away.
Okay, I will try to briefly answer to all of them. What can be done to ensure that all SA will react the same? I mean, this is really what we are working on with a lot of exchange, guidelines, working together. We make, I mean, I'm not referring to, but we are making also some trainings program, like on BCR. We just had one in Croatia to train the DPAs that are not so used to have a BCR. On the method of the calculation of fines, it was not an abstract work. In fact, we made a real test case with concrete case and with many authorities around the table, and they had to issue the fine and to see it will be harmonized in practice. So not only theoretical guidelines, but really on the practice. So we are doing a lot. Exchange program, I mean, this is something, this year there will be 40 exchange programs that we organized between the authorities. So people, staff were going to work like some months in another authority, sharing knowledge from their authorities, learning from that authorities, coming back. So, I mean, there are many actions that are even not said here, but we are doing. On the scope of the procedure, I mean, it depends. If there is a guideline, if there is a complaint, that's the complaint which is setting the scope. If it's our own volition, I mean, on this one, it's true that the DPA has more flexibility. We have underlined in the guideline 65.1a that a CSA can raise an objection on the fact that the scope is too narrow, and then the DPA, the LSA, has to take this into consideration in this draft decision, or to split and to have another. If it will take some time to make also this investigation. So this is what we are doing on that. Centralization, this is, I mean, the system of the GDPR, it's not an exclusive competence. So in practice, the LSA is not like having all the power. In fact, there are possibilities for CSA to raise objection, to have a board decision. So it's a mixed, I would say, solution. Proximity has been raised by Florence. It's very important. We need to look at Article 13 of the Convention of Human Rights, have a right to go to your own country, to also make a complaint to your DPA or to your Court of Justice, because this is a fundamental right which make a difference to the others.
Okay, very quickly, Filipe, please.
Thank you. So I will be very, very brief. So I acknowledge the issue of discrepancies in the way in which DPAs operate and how they interpret the GDPR and handle cases. But I think if we consider other experiences in EU law enforcement, we have to manage expectations, I think, because if you consider, for example, the European Competition Network, it took a decade, more than a decade, for a common competition law enforcement culture to emerge between all the national competent authorities. But I would certainly agree with you that there is a body that there is a level of administration that is especially well positioned to try to harmonize this culture, to foster that common culture, and that will be the union level. I would say that the EDPB will be a great body to promote this. So in terms of the questions about the right to be heard and the scope of the disagreement with the RROs, I would agree. how you distribute the burden of the right to be heard is a complicated issue. But again, I think that if you consider that the case law of union courts has given many solutions to this issue, taking into account only two things: the structure of administrative procedures and the interpretation of general principles of EU law, such as indeed the right to be heard, not the policy fields, right? If you consider this, I think you can already find some of the answers that you're looking for if DPAs are obliged to hear, if the board is obliged to hear, under what circumstances. I think you can already find many of the answers when looking at this case law. Finally, the issue of the scope of the disagreement here, I would completely agree with Havik that this is, for good and for bad, a discretionary choice of the LSA, how it defines the scope of disagreement. There are ways to review discretion, but it's not simple. Thank you.
Thank you very much. Lisette, please.
Yes, just very quickly, I want to say that I very much agree with Brianna that the role of the EDPB seems too soft, and the EDPB is doing a lot, but it's non-binding, decisions are very broadly formulated, and there's always a lot of room for DPAs not to comply and go their own direction. So indeed, I think that is something that has to be considered, and not per se by centralizing the whole system, but by moving different competences or tasks to the board. And with regard to the procedural rights that are already in place, a very important point here is, I think, that it is very uncertain if you are actually a party to the procedure, because there are certain authorities that do not act on the complaint, but start an own volition inquiry instead. And you are no party to the procedure with no procedural rights then. And this is also the case if you submit your complaint with a concerned authority, and that authority forwards your complaint to the lead authority. You are often also not a part of the procedure then, so you can have your procedural rights, but not being a party will not bring you any further.
Exactly.
So that is a real gap in the system, I believe.
Thank you very much, Johannes. Unfortunately, you're the last man between this audience and coffee.
Okay, so
Please,
I
30
will be
seconds.
very, very short. I think we had a great discussion, and it is clear, and I think that we all can subscribe it, that we had needed first legal security, and especially the effectivity of safeguarding rights and freedoms of people, and therefore we have two possible solutions. The bone of contention is, will the legislator step in? Will he step in? Then he has to think about changing the system from within. That means structural thoughts about the procedure, changing the competences of the actors, and bringing new harmonized law in. Or he will do it on a large-scale number. Then he will shift the whole thing to a centralized body. And this could be somebody in the EDPB, on the European level, the EDPS. I mentioned this, but I guess it must. The time frame is very short because time runs away. We don't have much. Time runs away, so we don't have any problems having our coffee now.
Exactly. I think so many ideas still to unpack going forward in discussion. I'd like to thank you all for staying. Please be aware that the keynote speech of Wojciech will kick off at 11:45 in the main auditorium. Be there. Thank you so much for attending. Please give a warm round of applause for these excellent speakers. And thank you so much, each of you, for your intervention. Thank you.